All right, let's dive right in. Today, we're talking about one of the most powerful and honestly most overlooked skills you can have in a courtroom, mastering the official court record. If you get this right, it can be a total game changer, your secret weapon. So let's get into it. Let's just start with this quote because, wow, it says it all. If it isn't said on the record, it legally did not happen. Think about that. That chat you had in the hallway? That comment the judge made offhand? If it wasn't officially recorded, a higher court can't consider it. It's like it vanished into thin air. The stakes are really, really that high. So what is the record exactly? Well, think of it as the official permanent story of your case. It's everything that happens when a court reporter is typing away or a digital system is recording. Every single word of testimony, every piece of evidence that gets admitted, every ruling the judge makes, it all goes into this one permanent account. Okay, this is the best way to think about it for sure. The court record is the official game tape of your legal proceeding. And if you ever need to challenge a bad call, appeal a decision, the appeals court can only watch what's on that tape. If your key piece of evidence or a critical objection didn't get recorded, they can't see it. For all legal purposes, it just didn't happen. So, with that game tape idea in mind, let's break down exactly why getting your story onto that official record isn't just a good idea, it's completely non-negotiable. This slide draws a really, really clear line in the sand. On the record, you've got the official stuff. Spoken testimony, evidence the judge actually admits, and the judge's formal rulings. But off the record, that's, well, pretty much everything else. That agreement you thought you made in the hallway, that discussion during a settlement conference, it has zero legal weight unless it was formally put on the record. Understanding this difference is absolutely critical. So here's the why in a nutshell. First, it protects your future. No record means no appeal. Simple as that. Second, it's about accountability. It keeps everyone honest and tied to what they actually said and did. No changing stories later. And third, and this is huge, it builds your credibility. When you're focused on making a clear record, you look professional, you look prepared, and judges absolutely notice that. Okay, let's get practical. Success with the record doesn't start when you walk into the courtroom. Nope, it starts way before that. It all begins with your pre-hearing playbook. Before any hearing, you need to create a record plan. It sounds fancy, but it's pretty straightforward. First, what's this hearing really about? Nail down the core issues. Second, what facts do you have to prove to win? List them out. Third, and this is the magic step, match every single fact to a piece of evidence. Which exhibit or which witness proves this fact? And last, think like your opponent. What are they going to object to? And how are you going to handle it? You want to know a brilliantly simple but incredibly effective tool? An exhibit index. Seriously, it's just a basic table. You list your exhibit, you say what it is, and you explain why it matters. This little document is your roadmap. It keeps you organized, it helps the judge follow along, and man, does it make you look like you know what you're doing. And here's a super practical rule you should just burn into your brain, the rule of 3. For every single exhibit you want to use, you need 3 copies. One for the judge, one for the other side, and one for you to work from. No exceptions. This little bit of prep avoids fumbling around and shows a ton of respect for everyone's time. Okay, prep is done, you're in court. Now we gotta talk about speaking for the record, because trust me, how you say things can be just as important as what you're saying. This slide is perfect. Just look at the difference. On the left, everything's vague. A court reporter can't tape out you pointing a finger or know what this means. But look at the right. Strong, clear, specific. You're not just saying this happened. You're saying on March 15 at 3 p.m. I arrived at the school. You're painting a crystal clear picture for that written transcript. And these phrases, these are your tools for making sure that picture is perfect. If you misspeak, it's no big deal. Just say, to clarify for the record, and fix it. If you're talking about a document, announce it, referring to Exhibit B. Using these phrases is like speaking the court's language. It helps create a clean, accurate record that anyone can understand later. Next up, a topic that can feel a little intimidating, objections and evidence. But I want you to stop thinking of objections as being argumentative. Think of them as a shield. They're an essential skill for protecting your case from bad information. So, why do you have to do it? It's all because of a legal idea called waiver. Basically, if something improper happens and you just sit there silently, the law says, well, you must have been okay with it. If the other side tries to sneak in some bad evidence and you don't object right then and there, you lose your right to complain about it on appeal. Forever. You have to object to keep that issue alive for the record. And you know what? The process itself is surprisingly simple. It's just 4 steps. 1, stand up, it shows respect. 2, say objection in a clear, firm voice. 3, give the legal reason, like hearsay or relevance. And 4, this is the hardest part for most people. Stop talking. Just stop. Let the judge make a ruling. That's it. And look, you don't need to memorize a whole law book. Just getting a handle on a few of the most common objections is a huge advantage. Relevance keeps things focused. Hearsay is for blocking that unreliable he said, she said stuff. And foundation just means, hey, hold on, they haven't proven that this piece of evidence is even what they say it is yet. Okay, we're on the home stretch. But what happens after the hearing is over? Your job managing the record isn't quite done when the judge bangs the gavel. There are a few more crucial things you need to do. Think of this as your post-game checklist. Before you even leave, make sure the judge has made a clear, on-the-record ruling on everything. Then, go right to the clerk and find out how to order the transcript. As soon as you get it, read it. A single typo in a date or a number could be a disaster. And finally, get all your deadlines for what comes next down on a calendar. So, at the end of the day, remember that the court record is so much more than just a bunch of words on a page. It's the backbone of your case. It is the only story a higher court will ever get to read and the only official proof of what actually went down. And I want to leave you with this one final thought, because it's maybe the best piece of advice there is. Go into every single hearing and act as if a future appeals court judge is reading every word you say on a piece of paper. Because you know what? One day, they just might be. Make sure the story they read is the one you actually meant to tell.